Okay, hey everybody, welcome to She Sparks Society, and today's speaker meeting is with Katherine Van Marter of Van Marter Law in Asheville, one of our favorite real estate attorneys to work with because she's not only just a pleasure to know, but she's really knowledgeable. So we wanted to bring her in today. So that we can make sure that we're covered from A to Z when we're thinking about protecting ourselves as agents and also our clients. So she has some bullet points she's gonna talk about so we can keep our ducks in a row and stay protected. So take it away. Thank you for being here.
Yeah, no problem. Thank you so much, Beth, and y'all for having me. Like Beth was saying, my name's Katherine Van Marter. I'm an attorney here in Asheville, North Carolina. My practice is predominantly focused on residential and commercial real estate, although we like to say if it touches or concerns the ground, we're probably a good person to at least ask about it first. If we can't help you, we'll point you in the right direction. So we are a women-owned and operated firm. We focus on crafting curated client solutions for all people on all paths. We want to support everyone from our first-time home buyers to our veterans to, our 20 millionth property investors. It's very important to us to create that curated experience for everyone. So that's what we try and do. So when Beth had reached out to me to talk to you guys about kind of things, roadblocks or liabilities that I see, I kind of thought of three different topic areas. So I thought I would go over those three things that I've seen a lot recently. And then we can, if you guys have any questions or, whatever else you might want to discuss, I'm happy to answer them. So the first thing that I wanted to discuss is disclosing disclosures on the MLS. So what do we disclose on the MLS when it comes to improvements to real property, right? So a lot of times, especially in the Asheville and Western North Carolina area, you're seeing, a property that hasn't been sold in 10, 15 years, or it was sold 5 years ago to Handyman Joe, and Handyman Joe has done a lot of work on that property and really improved it. And it looks great. We're proud of Handyman Joe. We're proud of the old owners, but he didn't get permits for all that work. And so you're in a situation where you got to decide, what am I going to disclose, right? When you're walking around, the real square footage looks like it's 1,500, but the permitted square footage is about 800. The reason that this is important right now, determining, what to disclose in that particular situation, is because counties throughout North Carolina are implementing initiatives in order to better assess and get closer to the accurate property values so that they can tax those properties appropriately, or inappropriately, depending on your opinion, right? However you want to look at it. So the reason that's important right now is because sometimes when listings are coming up on the MLS and they're saying amazing basement, totally refinished, the tax assessors are coming in and saying, whoa, 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 whoa. We didn't know that was a finished basement. So we're going to come out and we're going to look at that property and we're going to give them what's called a discovery tax bill. When that discovery tax bill is issued after closing because they found out about it during your listing, you know what? The seller or the buyer is responsible for that. And that creates problems, and we're seeing this more and more. So how do you fix that problem on the front end? How do you protect yourself, right? Because where there hasn't been a disclosure on the MLS that the work was unpermitted and there's discovery tax bill, well, that's something y'all can get in trouble for. It's also something that becomes a title insurance claim on the property, which isn't great. It costs the buyers a lot of time, effort, etc. So to avoid that, my recommendation is to be specific, say basement has been finished. However, However, we make no disclosure as to whether that work was permitted. If you're not sure, or, say, unpermitted second bathroom addition, but it's really pretty beautiful. Come check it out yourself. So that's step one for the MLS, and that's protecting you guys, right? That's protecting you as agents from pushback from a non-disclosure perspective, from not making material misrepresentations. Ma'am, Beth, do you have a question?
I do. So if it is unpermitted, then we cannot list that as square footage.
So I think that's kind of the area where it's a little bit difficult, right? Because you guys have to stay within a certain range of the actual square footage. So what I would recommend is saying something along the lines of, for example, my house has an unpermitted 372 square foot apartment in the basement. So what we've done, or what I would have recommended to that agent to do, is put, they've put, I think, the whole square footage, the 1,500 square feet for the whole house, right? What I would have recommended is they put 1,200 square feet with 300 unpermitted finished square footage. And this is going to lead to difficult conversations, right, with your sellers sometimes, but it can save them a lot of time, hassle, money, and lawsuits in the future. If they have done unpermitted work, if it's substantial, what you want to do is perhaps even disclose that to the county. Go ahead and disclose it. Go ahead and get that discovery tax bill. That's not only going to set your client up for success as a seller, because they'll know exactly what the tax liability is, but it's also going to prevent any frustration, anger, upsetness on the part of the buyer or their agent in the future when their house comes out and gets reappraised, and say they don't even get a discovery tax bill, but they just decide to tack it on to the next bill, right? They say, we're going to raise your taxes by X amount. Well, now that has impacted the escrow account. It's impacted how much they thought they were going to be spending monthly. It's impacted everything about that buyer's transaction. So being proactive might feel crappy on the front end towards the seller, but it ultimately is going to save them a lot of time and hassle, and save you a lot of time and hassle in the future. Because what we're seeing right now is buyers that are reaching out and saying, oh my gosh, I just got this tax bill, I don't know what to do, right? And we have to go back, look at MLS, look at, the different situations. And oftentimes, that's not coming back on that agent, but it certainly could, it certainly could. And I think if there was something terribly egregious, if the tax bill jumped from $800 to $8,000 because, half the house was unpermitted, then, you're going to be looking at pushback from that.
Catherine,
Whereas
I have
if
a
it's just a little
question.
bit. Yeah, of course.
So along this line, so this actually happened to buyers of mine about 6 months after they closed on the property. They got a discovery tax bill, and the county is going back like 5 years and
Correct.
comparing MLS listings, the number of bedrooms and bathrooms. So it was a situation where it wasn't even the sellers who sold my clients the property. It was like 3 owners ago. And they said the tax is, is tied to the parcel, not to the owner. So whoever's living there has to pay the tax or have a tax lien put on your property.
Exactly.
So it amounted to like a $3,000 tax bill because they said it's, $600 a year difference in your tax assessment. So it was a 5-year bill, and it just, of course, it just like rubs everybody the wrong way. Is there any sort of like statute of limitations of how far back the county can go?
Yeah. So from my understanding, and I'll have to double check this and I will email you guys so you have the exact number, but I believe that the 6 years is the maximum for discovery tax bills. So, and I don't think that they're going to go for less than the maximum. I certainly wasn't. If I was in the tax assessor's office, I would be looking back as far as I could to see what that difference was, because that's their job, and we should, they're going to do their job, right? But when you have a client that's faced with that situation, and there weren't the proper disclosures on the MLS, that's an appropriate time for them to be able to file a title insurance claim. If there were disclosures on the MLS, then that's not going to be covered by title insurance in the same way. And title insurance is still kind of figuring out how they're going to handle that. So I'll keep you guys posted as we get updates. And, I'm dealing with this with actually 2 clients right now, and I'm walking them through the situation. So as I walk them through that, I'll keep you guys posted on how things go. But where there were no disclosures on the MLS, so there was no way for the borrower or the buyer to know that there was an issue in advance, then, at that point in time, that becomes a much stronger title insurance claim. And this is what, we all don't want to use our title insurance. It's always a bad situation when you have to use your title insurance, but that's what we get it for. So,
well, and in this case, like you couldn't even hold the sellers or their agent responsible because they didn't know it either. So it was like, like at the end of the day, like who's responsible?
Yeah. And that's a really, really difficult question to answer, right? Ultimately, you're looking at the individual who did the unpermitted work would be the appropriate party. But there also is a level of responsibility, both, throughout the transaction from the seller who maybe didn't do the unpermitted work, but has reviewed their tax property card, and you can see what the square footage is on your tax property card, versus what they have. Or the agent who, reviewed the permits on the history of the property, but just, didn't quite look as closely as they could have to the attorney when they're doing the title work, to making sure that we're looking at everything possible and taking every possible step that we can to catch this before closing, so I know myself and most attorneys in town now are doing tax updates. We always do title updates, but we're also doing tax updates throughout the transaction to make sure that, if a discovery bill does come out, we can catch it as quickly as possible. And we do those up to 30 days after closing. And that's, because that covers all that we can, that's all we can do, so double checking those property cards, saying this doesn't feel right, this says that this is 10 or 1,000 square feet, and by my measurements it looks more like 1,500. Looking at that and saying, where's the rub here?
Well, I think everybody operates under an assumption that like the tax department is like the IRS, like it runs 3 years behind. So
yeah,
like, the assumption is it's going to take them a while to catch up to like reality. So it's a little counterintuitive to think like, oh, we're supposed to like raise our hands and say, oh, hey, pay attention over here. There's actually another bedroom and another bathroom.
Yeah.
To measure, like, because sometimes they don't even come to the property. They do like virtual assessment.
Right.
They don't even get in the house. So it's just such
and that's what these are really is a virtual assessment where they're finding it on the MLS and they're saying, well, this doesn't look like what I thought it was going to look like inside. This doesn't match up. And, I think it's just important to be aware that while that's the mindset that we have had, that we have to shift our mindset to be more prepared, because this is an initiative that they're participating in, and to protect ourselves and protect our clients, whether buyers or sellers, just taking that extra 2 seconds to look and double check that square footage, double check any permits that you see. That's something that hasn't always necessarily even been a priority for, title work, to make sure that the square footage is perfect, because we're looking at that for you guys doing that. And now that's become a real priority for attorneys, is making sure that we're looking at that, because at the end of the day, when the discovery tax bill comes out, the agent's back involved, we're back involved, and we want to make sure that this client is taken care of. That's that. I feel like at least that's my responsibility, and the agent's responsibility for the buyer. and, you know, to take whatever steps we need to get them in the situation that they need to be in.
Are you aware, Catherine, of this happening? Like, I mean, obviously this is happening in Buncombe County. Are you aware of it happening kind of across the state in other markets? Like, I don't know what you hear in your kind of circles.
Yeah, we are hearing about it across the state. You know, there's whispers here and there. You know, I don't think this is, let me put it this way. We did, you know, about 500 closings last year, and we've seen this come up twice. Once in Buncombe County and once in, I think it's Madison County. So, you know, and those were two you know, markedly different situations, just polar opposite situations as they possibly could be. One was like, I don't know what's happening here. This is obviously a lot of unpermitted work. Good luck, Godspeed. And the other one was, you know, this is a beautiful home. We've done a great job. You know, everything is on the up and up. And so those two different situations obviously have to be handled in very different ways, but it's not like we're seeing this in 1 every 5 closings, right? But the other side of that is, you know, encouraging clients when they're doing work on their homes to prepare them for sale, get a permit. You know, I know it's expensive. I know it's a pain in the butt. I know you don't want to do it. You know, I know that you might not be sure if you even need one, but you might as well just get the permit. Get the permit, spend the $150, $250, $350, whatever it might be. And save yourself the hassle of having to deal with this down the line. Like so many things in life, if you have the money, throw the money at the problem, and it'll solve it on the front end. Yeah, questions about that? Okay.
No, thank you though. That's really useful.
Yeah.
Yeah, it's good to watch out for.
And I will keep you posted as I get through these. You know, I've kind of been keeping notes, and from, you know, I went and spoke with Beth's Realty Group, you know, her team a couple of weeks ago, gosh, probably months ago now, it feels like. And, you know, I have been keeping notes so that as I go through this process with these clients, I can kind of update you guys as we go along and figure out, you know, what went wrong and where could we have done things differently, or could we have done nothing differently, you know, as a whole team for that buyer, for that seller. Is there nothing we could have done, you know, or are we just out of luck? But any tips and tricks, I will pass them along as I learn them. But I would say for now, err on the side of caution. And if you're not sure, you can always ask, you know, ask me, ask another attorney that you're working with. And, you know, get some help assessing that risk. Ask your BIC, get some help assessing that risk. You know, a 200 to 300 square foot addition that is or, you know, finishing of the basement, like at my house, is probably not that big of a deal. You know, it's probably not going to end up with 5 years of $1,000 tax bills, right? But, you know, if you're talking about a 1,500 square foot basement, well, that's a different situation. Bathrooms are important. Anything that really needs a permit, bathrooms, HVAC, things like that, right? Any plumbing, any HVAC, anything that really, really needs a permit should be a red flag. For should we be disclosing this now so we don't get in trouble later? Because the fear there and the thing that you want to prevent is, you know, litigation, right? That's what we're all trying to prevent all the time. And so by doing a good job on the transactional side. And we never want to be in a situation where there's a question of who's responsible for what. If we're clear up front, then we know who's responsible for what. Everyone. So that was the first thing I wanted to talk to you guys about. The second thing that I've seen a lot recently that I think is, you know, a kind of easy fix, but something that folks don't think about, is seller credits. So we have been seeing, especially in this market where there's a real rush to make the best possible offer that you can, right? And that makes sense, right? You want to put in the highest and best that you possibly can so you get that for your buyer. But then down the line, your buyer says, oh, well, I'm gonna have to do this and this and this, and I would like, X amount in seller credits or whatever. I think the house is really worth to me 500 instead of 550. So rather than doing a purchase price adjustment, you'll do a seller credit. And we see that a lot where we're looking at anywhere from $10,000 to $50,000 worth of seller credits, which great, not a problem if you're in a cash transaction. But if you have a lender, that's a real problem. We can't use all that money. And you as agents and I as an attorney want to be very careful that we're not breaking any laws, right? We're not committing loan fraud. We're not aiding and abetting loan fraud. We're not breaking any RESPA. We're not committing any RESPA violations. It is very important to make sure that you can use as much of that credit as possible, or set your buyer's expectations that they may not be getting that much. So for example, you have $10,000 that you got in seller credits, and you're able to use, with the lender, you're able to use 5,600 of it. So you've got 4,400 left to use. How are we going to do this? Your buyers are mad that they're losing the 4,400. They're mad at me. They're mad at their lender. They're mad at you that they can't get that extra 4,400. And we're all scrambling because this is always something that comes up right before closing, because we get the amendment. No one thinks about it until we're balancing with the lender, right? And then it comes to the balancing with the lender and we're like, well, what are we going to do with this extra money? We got to figure out a way to use it. First of all, I recommend keeping your seller credits low, within the $5,000 and below range. That will always likely be usable if you're buying a house between, 350 to, 800,000. We can probably use $5,000 in seller credits up to $5,000. Over $5,000 is where we need to start getting specific about how we're using that money. So say, back to our example, we have that 4,400. How can we use that money? Well, it depends. We can pay contractors at closing with the consent of the seller. We do need a due diligence request for that, though. So, for example, a seller with this 4,400, there is a seller, there's a contractor that your buyer wants to pay at closing to paint, right? That's perfectly fine. Or if there's minor cosmetic repairs, those are generally things that would be okay with the lender. But if this is triggering major repairs or reappraisal concerns with the lender, then we're not going to be able to use those funds, and they shouldn't be used for that, for a contractor. But if you're looking at minor repairs or things like that, that's generally fine. And this is something you always want to confirm with the lender before you do it, is because they're the ones who have to make that ultimate call. But generally, as long as we have invoices, we can apply those to the seller side as long as everyone's on the same page, right? So say, because think about it, right? Even if it wasn't for a seller credit, if you guys wanted to pay a contractor at closing, you would be able to do that with an invoice. And that's totally fine. Just everything has to be upfront and transparent to that lender. Do you have a question, Beth?
Yeah. So you were saying the lender is the one that always sets the amount of maximum seller credit, right?
Yeah. So it's generally about 3% of the loan amount. But what we find is that when the loan officer is looking at it and we're looking at all the other closing costs, and some can be used and some can be not, there tends to be some overestimation on how much can be used. Same as us, we want to give people the answer they want to hear, right? And oftentimes when it comes down to, in my office, Erin, my paralegal, and the closer who, you guys have never talked to before because they're in the back of the bank, balancing that settlement statement, they're like, yeah, no, we're not doing that. And that's who we really need the yes from is the closer. They have to say yes, the closer and the underwriter. So that's one way we can do that with that extra amount. The other, but again, it has to be above board. We have to get approval. We have to have invoices, and it can't be for anything serious like your roof or whatever, unless those are things that were disclosed on the appraisal, et cetera, right? The other thing we can do is hold money in escrow. Almost every attorney I know is going to charge you money for that agreement and for for holding the money and dispersing the funds. The other thing about holding that money in escrow is that everyone has to agree. Again, that's the biggest thing here. Transparency. Everyone has to agree. And again, it can't be for repairs that would impact the structural integrity of the home, the roof, the HVAC, the plumbing, the serious stuff that the lender goes out and checks and makes sure their investment is worth it, right? If we're talking about painting, things like that, that's fine. And you want to make sure that this is all, again, disclosed to the lender. They understand what's going on. So, for example, you guys have a $10,000 seller credit that you want to use. You're able to you submit your due diligence request alongside that. You submit your, agreement to amend and a due diligence request to repair whatever, right? The refrigerator, the toilet, the wall that, something happened to. And the seller doesn't quite get that done before closing, but they're close. That's a great time to use that extra seller credit towards the escrow agreement. Or you can structure it as, we're going to put $5,000 in seller credits, and we're going to hold $4,000 in escrow for repairs to the kitchen, and those are ways that we can work, or $5,000, excuse me, for the $10,000 in escrow for repairs to the kitchen. And that is totally fine. We can do that. We just have to have everyone agrees. And most escrow agreements are going to be fine with lenders as long as we get them to them on time. So planning in advance for using less towards seller credits, or, using an appropriate amount towards seller credits. I shouldn't say less, but using an appropriate amount towards seller credits, and then knowing exactly what you want to do with the remainder of the amount that you'd like. Planning in advance for that, just send that over to us, send that to your attorney, send that to your lender, and they'll generally be okay with an escrow agreement. We just have to get it to them in enough time for them to not have to go back to underwriting, which I'm sure you guys have all heard lenders say, well, we're going to have to go back to underwriting for that. That's what we're trying to avoid, because we don't want to avoid, we don't want delays in closing. But if we get it before they go to underwriting, then we're generally okay. And full disclosure, different attorneys have different takes on that. Different attorneys want to handle that situation in different ways, and I think that's totally fair, right? There are different approaches to it. And always the best solution is just lower the purchase price. I know it's not the answer that you want to hear. I know, but it's the best way to do it. It's the best, safest, easiest way to do it. Again, I know, not the answer you want to hear, but you do have options. And if you're not sure, ask. Again, ask me, ask the attorney that you're working with, ask the attorney on the transaction. How do we do this? Ask the lender, they'll help you. We're all working towards the same goal, which is happy buyers, a smooth closing, everyone getting along, things going well. And the easiest and most efficient way to do that is by being transparent and asking questions as far in the future as you possibly can, so you get your answer with plenty of time to make decisions if you need to make changes. And just setting, reasonable expectations. We are asking for $10,000 in seller credits. Your lender said we'll probably be able to use most of them, but don't expect to get all of it. You're probably going to get a little less than that, right? But we'll do everything we can to get you as close to that amount as we possibly can. Setting that expectation up front leads to less painful conversations for me, for Aaron, for you guys. 3 days before closing where everyone's already stressed out anyways. They want to be worrying about movers at that point. Questions about that? Cool. Other thing that I kind of wanted to bring up, which is a little bit smaller of an issue, but something that I have been seeing frequently recently, especially with builders being as behind as they are as new construction. We get a lot of questions when it comes to closing time on new construction. Hey, the bathroom's not finished, the whatever, right? Whatever it is, they didn't remove the deck like they said they were going to. What survives closing and what doesn't? And how do we make sure that our clients are protected? So biggest thing for that is use the right forms on the front end, use the new construction forms on the front end, use them, because what that does is that protects the client immediately by saying, you have a punch list. When we get to closing, everything that's on the punch list survives closing. And that makes it really easy. If you don't use those forms, then we're going back and forth. We're coming up with amendments and addendums and all this other stuff. And, that's already written in on the front end. So if you use that form, you're in good shape. Then when you get to the closing table and you say, this isn't done, this isn't done, this isn't done. Well, of course, it's up to the buyers whether they want to go ahead and close or not. And we're happy to delay closing until they're ready. That's not ever a problem, at least for us. I won't speak for anybody else, but I would imagine they feel the same. That being said, punch list items do survive closings, and builders, contractors have an obligation to get those punch list items done within a reasonable time frame for that item. I wouldn't personally want to close on my house if it was missing, major components or things that were stressful for me. We had a client recently whose water wasn't on yet, and they were really stressed out about that. And I said, let me know when the water's on, and we'll be here if you guys want to re-sign, that's fine. They didn't want to close with that, but that would have been a punch list item that would have survived closing. The other question I get about punch lists at closing is, what's the form of the punch list? Does it need to be in writing? Does it need to be signed? Does it need to be autographed? Do you need to witness it? What's the deal here? Pretty simple. Anything in writing will do. But what I recommend is, a lot of times what the builder will do is or the contractor will do is he'll do the final walkthrough with the buyers, and they'll write everything down on a piece of paper, and then he'll have them initial at the bottom of it. What I always recommend is take that list, take a picture, type it out, send it to the attorney. The attorney has it. We know what's on the list, right? And again, this is my preference. Probably every other attorney out there is like, shh. But that's what I always like to have happen, because then if there is anything that happens after closing, I know exactly what happened and when it happened, so I can best support my clients. And so do you guys, right? And a lot of times that happens without the agent present too. They'll do the final walkthrough without the agent. And in that case, extra special for you guys to get that picture, type it out. And generally what I do is, when I get the punch list photo, we do a lot of non-agent new construction, unrepresented new construction. And what I do is, when I get the little photo of the sheet that they wrote it down on, I type it out, I send it to everyone, I send it to the builder, I send it to the builder's attorney, and I say, this is our punch list, please acknowledge. And then we've got the, yep, okay, thank you. We all know this is the same. And yeah, like I said, that's kind of a quick one, but something that we're seeing a little bit, more frequently is issues with that. But they do survive closing. You are protected as a buyer. Yeah. Questions about that? I think that's something most people know, but we have seen a little bit more of a funky questions with that lately. So I thought I would reiterate.
I have a question, but it's not related to that. And it might.
Yeah.
It's for a seller, and they have a neighbor who is when they went out of town, they replaced and redid a shared driveway without their permission. They had said, no, we're not interested in participating in revamping this driveway. And they went out of town, and then the neighbors did it anyway. And then they're asking them to pay half of it. And they're like, no, so they're going into litigation for that. Now they want to put their house on the market.
Yeah.
How will that affect it?
Yeah, that will definitely impact their the sale of their home. So until that litigation is completed, so the way that, and this is speculation, right? So just, I'd have to look, first of all, I'd have to look at the shared driveway agreement. I'd have to look at everything else. So this is just general speculation based on very limited information. But if they're being sued by their neighbors for the full amount, or, the 50% of the amount of the improvements, well, whether they think they're going to be successful or not, that would be a lien on title, or a blight on title until that was resolved. Because we don't know whether there's going to be a judgment that directly attaches to the property at hand until that's resolved. And there are different ways to handle that, but in my office, I would make you pay the judgment at closing, as my seller, probably, if there was one, because otherwise we couldn't get clear title for our buyer.
Okay,
Yeah.
that's interesting. So their
Yeah.
fear is, if it's not a huge amount of money, but it's enough, and their fear is if they just say, okay, we'll just pay half of the driveway repair, then the neighbor's cuckoo enough to start another issue. So their fear is if they give in, but if at closing that could be paid to clear that off of the title, then that's a way to solve another litigation down the road in between the sale. I hope that made sense.
Yeah. So if they decide, say that the total amount for the repairs was $5,000, they're $2,500, right? Or the neighbors claim their own $2,500, and the sellers don't want to pay it. Well, if they just go ahead and pay the $2,500 out of the closing costs, that should be okay, but we would need to see a dismissal filed. But if we pay what they're asking for, then there is no harm at that point. So yeah, I mean, I would be, very, very, I'd have to look at the situation specifically, but as a general statement, if there's not money owed and the litigation is going to be resolved by the payment of this, then I would be okay with that. I would just be very involved in making sure that the litigation was actually dismissed. I would make sure that we've reviewed all the documents related to the litigation, etc. But yeah, I mean, that would be one way to handle both the litigation and any judgment that they had against them as a result of it.
Yeah.
Which they may not. I mean, they may be successful. So
yeah, they just want to sell their home. They're ready to get out of Dodge.
Yeah.
There's a lot of crazy neighbors out there.
There are a lot of crazy neighbors out there. Yeah. And guys, I'm going to move locations because our sellers are here a little bit early, but I'm going to stay on with you. So just don't mind me moving here. You guys can see my office. This is our conference room.
Yeah. And it's okay too if we need to end a little early. If anyone has any other questions, go for it. Otherwise, I feel pretty covered, and this has been super useful. Thank you.
Good. I'm glad.
Does anyone else have any questions?
Yeah, and whether they're specific or general, I'm happy to, touch on them as much as I possibly can. And, if there's anything I can follow up with later as well, I'm more than happy to do so. We are, it's definitely a priority for us for our transactions to go smoothly. We value work-life balance and happiness in our office. And one way to get that done in a very efficient way is to, be good at your job and help other people be good at their jobs too. So if we can ever help with anything on the front end or back end of a transaction, whether you're working with us or not, that's perfectly fine with us. We're more than happy to help. So, questions?
Anything else?
Comments, concerns,
Anybody?
feelings?
Feelings. I'm going to do feelings.
Yeah. I always say that in
Well,
closings,
super-
and people are always like, "Are you sure you want that?"
Yeah, this was
Sure, lay
really
it on me.
helpful, really practical, took good notes. So thank you.
Yeah.
Yeah.
Yeah, and thank you guys so much for having me. It's great to be here. And if there's ever any way we can support you, just let us know. We're all in this together. So
Catherine, where's your office?
it's in the River Arts District in Asheville. So it's on the corner of Bartlett and Depot Street. Do you know where Penny Cup Coffee is? It's right next to
Yeah,
Penny Cup
okay.
Coffee.
Great.
By their roasters. Yeah. We have parking. Big selling point.
No kidding.
Yeah.
Okay.
Easy parking. Yeah, and if you guys have any other questions about, where we're at on transactions or things like that, we are pretty busy for the rest of March, but we're always available. We try and stay about 2 weeks to 30 days ahead on our title and things like that. So generally okay for anything within a 30-day period. If it's less than that, just let me know. One of the things that I do is if you have something you need to close fast, just let me know and I'll do a quick look at everything on title. And I'll be like, yeah, no, that's not going to happen for you. Or sure, that sounds great. Let's do it. Most of the time, you can figure that out pretty quickly, whether it'll be a pain or difficult or a delay or not. So we're always happy to help in advance. And
they're
shout
great
out
to work
also
with, too. I've always had a wonderful
Thank you.
experience working with you. So
I appreciate that, Beth. I was it's very kind of you to say. I appreciate that. I was going to say I was in traffic on the way from to Beth's last closing with us, and I've never felt so bad about anything in my entire life. I was like, she left. I almost cried. So I really appreciate that.
it was all cool. We're laid back. So
yeah. You're laid back.
And sorry I'm late to the
That's
party,
very true.
but I
Hey.
also want to say I'm Team Catherine. She's fantastic. I have personally worked with
Thank
her
you.
on escrow construction situations. So if you need a GC who cooperates well with escrow GC agreements, let me know. But her office has been great with that. So awesome. Thank you for everything today. This is great.
Thanks. Yeah. And plug for that. She does it the way we would like for people to do it. So she does do a very good job with that. So thank you for making it easy.
Oh, somebody's talking. Okay. Okay. Well, thank you so much. This has been such a pleasure. And we'll be seeing you at our next closing. So
yeah. Thank you guys. I hope you guys have a great rest of your day.
Thank you.
It's nice to see you.
See you later.
All right.
Bye-bye.
Talk to you soon. Bye.